think it actually came in through the state because we came up and checked it. And said,
Was it a different number through the state?
I don't know the number, but she came up, checked it, and said it came in through the state, and you didn't want a duplicate exhibit, but she didn't. I don't have the video, so that's fine.
Okay. Well,
We'll just make sure.
Make sure, yeah. Any other issues? All right, State, you may proceed with your closing argument.
Thank you, Judge. Your Honor, the test of the fairness of any judicial system is whether it can treat everybody the same. And here inside the four walls of this courtroom, nobody should be above the law. In this country, in this state, in this city, as Chief Eden said, the police must abide by the same laws they enforce on us. And so that's where we start, with the fairness and the fact that no one is above the law. What does the law say? I think we've proven what we told the court the law says that applies to everybody. The way we started in opening statement, you don't get to claim self-defense if you start the fight, which happened here both at the beginning with the open space officers and again when now, as Officer Weimerskirch has admitted, he invited Mr. Boyd to come down, pick up his bags and come down, and they attacked him a second time. You don't get to claim self-defense in that circumstance. Whether you're a police officer or a citizen, you don't get to claim self-defense if you create the danger. And that's what happened here in this case. Mr. Boyd did not advance on these officers. The officers advanced on Mr. Boyd, and it went from being in a safe area to an unsafe area. And finally, Judge, probably and most importantly, you don't get to claim self-defense if the victim poses no threat at the time that you shoot him. And this picture is taken before any of the 6 shots are fired, Judge. This is the picture of what all three officers have now testified they saw before the first shot was fired. Keith Sandy in his statement said, "I saw him turn to his left." Richard Ingram said he saw him turn to his left. And Officer Weimerskirch, even though he didn't say it in court initially, that's what he told the briefing people the very night this happened, that he'd seen him turn to his left. I think Sergeant Fox said, whether he's a danger depends on who's up there. There was nobody up there. He was doing what they told him to do at the time and posed no threat at the time they fired the first shot, the second shot, and the third shot that hit him. There is probable cause that this was not justified, just as we said we would prove in opening statement. What has been the defense response? Well, they have brought in every officer who was at the scene, and they all say the same thing as we, I think, predicted in opening statement as well. It's this, the Tueller drill, the Tueller drill, the Tueller drill, the Tueller drill. The consistency of their testimony is understandable. They want to protect their fellow officer. There is a blue wall of silence that they want to protect and not have somebody indicted when they shoot in this particular situation. The most interesting thing is the one person who did not hew to the line that everybody else was towing, and that was Sergeant Jim Fox, who came in and said to you, when presented with somebody turning and then with somebody turning their back to him, that he would not shoot. And he's one of the people that trains the APD officers, that then they are not a threat to you if they are turning away from you, if they're doing what you say and they're turning away. You do not shoot them in the back. That is against protocol. But there was an even more interesting person who said it's not the Tueller rule. The fellow that came in here who is the apologist for the police officers, Bill Lewinsky, the fellow who defends police officers in all kinds of circumstances. And we found in his own writings, in his own words, what he says the Tueller rule says. And here is what he says. The distance of a person with a knife cannot be the factor upon which a police officer decides to shoot. A person with a knife cannot be considered an actual threat justifying deadly force until he takes the first overt action in furtherance of his intention, like starting to rush or lunge towards the officer with intent to do harm, and even then, there may be factors besides distance that influence a forced decision. And here's the most important thing he said, Judge. So long as a subject is stationary or moving around but not advancing or giving any indication he's about to charge, it clearly is not legally justified to use lethal force against him. And that's the very circumstance that we have here. James Boyd did not only never advance or give any indication he was about to charge. At the time he was shot, he was turning to follow APD's orders to get on the ground. And that's obvious from the videotape. Not only is it not justified based on the tool or drill, it does not fit into any of the categories in the justifiable homicide by police officer instruction, which is UJI 145173, which says justifiable homicide by a public officer or a police officer. There's a number of categories. The only one that even remotely is close to our case is this one. Only if it is committed while arresting Boyd for a felony and he is fleeing from justice, which is Tennessee versus Garner. That's the only part of the UJI that would make this justifiable shooting by a police officer, but it combines that with something else, Judge. It says also a reasonable person in the same circumstances as the officer would have reasonably believed Boyd posed a threat of death or great bodily harm to another person. And those two things have to come together for there to be a justifiable homicide by a police officer. So, first of all, what was the charge? Was it a felony? Well, first of all, was he fleeing from justice? Let me start with the very first part of that thing. Was he fleeing from justice? Again, Sergeant Fox said when he was on the stand, Boyd could not have fled. We had established a perimeter. He could not escape. So he was not fleeing from justice, and as we know from the videotape, not only was he not fleeing from justice, he was turning and then completed the activity to lay on the ground. He was surrendering, he was laying on the ground and doing what the officer said. So this justifiable homicide by a police officer instruction doesn't apply because he wasn't fleeing. But what was he charged with? In truth, Judge, this is the thing showing that he was surrounded and couldn't get away. As much as they want to make this a felony, Judge, they were up there for a misdemeanor illegal camping citation. That's what they were up there for. And the appropriate way to have handled that came from Sergeant Chris Ware from the New Mexico State Police, who said they should have dealt with this by telling Boyd to move his tent 300 feet away to national forest land. Had he just moved 300 feet, had they just gone up and said, look, you can't camp here, you got to move your stuff, we're going to come back tomorrow and check, you have to be out of here by then, none of this would have happened. It was a misdemeanor charge, and I know they keep saying, it was no, he attacked the police officers, but had they charged him with the felony of aggravated assault on a peace officer for pulling out his knives in self-defense after the officers pulled out his gun, here's the instruction he would have been given in that circumstance. There is an instruction if you're charged with aggravated assault on a police officer that says defense against excessive force. A citizen has the right to defend himself against an officer using excessive force. Excessive force means greater force than reasonably necessary. And at two different occasions, they used excessive force on him, both at the beginning when these officers pulled their guns on him within 11 seconds of contacting him, and then again when all of these people surrounded him and lined up and used excessive force against him. And the two important times when he pulled out his knife is the first time that excessive force is used on him, when the guns are pulled and he's doing nothing, being completely cooperative there at the campsite. And then again, at the end, when he has his knives put away, he puts his bags on, he's coming down, they attack him again, and he only pulls his knife out again in self-defense when the dog comes up to him. And you'll see in the video, Judge, the dog comes up. I don't think the dog ever bit him because there's no wounds from the autopsy on that. Dog runs up, turns around, and comes back, and that's when he pulls out his knives again in what Officer Sandy accurately describes as a defensive gesture, not an offensive gesture, but a defensive gesture. But there are more rules. And I don't think you have to be mentally ill to think that you were acting in self-defense in these particular situations where there's excessive force by police, Judge. One of the interesting witnesses in this case was Alexander Thixton. He is the neighbor who called the police rather than call social services. Alexander Thixton, when police came to his home, was in fact armed with a deadly weapon. He had a pistol that was concealed on his person. He had taken that pistol along with his two Great Danes up to the campsite to check out the campsite before this, and he did not tell the police officers that he was armed with a deadly weapon. And when the police came to Alexander Thixton's home, they certainly didn't pull their guns on him in 11 seconds, nor did they even ask him whether he was armed with a weapon. And when I asked Mr. Thixton about why didn't he disclose to the officers that he was carrying a gun, he seemed really put out by that, almost outraged by the fact, that the suggestion that he should have had to tell them that he had a gun, because he said, just like Mr. Boyd said over and over again for 2.5 hours, he had a legal right to carry this concealed weapon, just like Mr. Boyd had the legal right to carry pocket knives that he used for tools when he was camping. And that's what the law says of self-defense. 145190, a person who is threatened with an attack need not retreat. In the exercise of his right to self-defense, he may stand his ground and defend himself, particularly when he's in his own home, just as Alexander Thixton was when they came to his house, and Mr. Boyd was when they came to his tent home. So there is no felony in this case. Finally, the jury instruction talks about what a reasonable person is. A reasonable person in the same circumstances as the officer would have reasonably believed that he posed a threat of death or great bodily harm to another person. And this is different than what the defense has been arguing throughout this case that you should look at. They keep saying, oh no, it's not a reasonable person, it's a reasonable officer standard, and you have to look at what officers were trained to do. And that can't be the law. I think it is probably appropriate that this case, this preliminary hearing, will be decided on the 10-year anniversary of the John Hyde shooting, where 2 officers were killed, officers Michael King and Richard Smith, along with 3 other people, by a mentally ill man, not with a knife, but with a gun. And since that happened 10 years ago, the pendulum has swung way, way too far, Judge. Both training of APD officers has created this unreasoning fear in these officers, I think typified by the videotape that you finally stopped them from playing in the court, that would scare young officers to death with the kind of, it was like a slasher video where they have people, you know, stabbing people through the window. Driver's license with a razor on it, and I suspect that's never happened in the history of this nation, that some woman has a razor that she attacks the officer with. That's the kind of stuff they are training people with, and you've got to be on guard, and everybody's a threat, and you've danger, 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 danger. In fact, their own witness put on, Ron McCarthy, the actual statistics about police officers who are killed with knives. He had a 10-year period of time in which 594 officers have been killed. Only 7 of them were killed with knives. That's the real danger to police officers from knives, rather than this made-up danger. And knives are not as dangerous as guns. If that were the case, if they were treated exactly the same, they would stop issuing police officers guns and just give them knives. Here in Albuquerque, as a result of what happened with John Hyde 10 years ago, the population that has suffered the most is the mentally ill population, part of the population that James Boyd was with. And it should not be police training or how they scare these officers that determines what a reasonable person should do. It is the law. And the UJI has the correct standard. The one case we have from which this UJI was created, and by the way, the UJI is the thing that was approved by the Supreme Court after the Mantelli decision. And they chose not to put reasonable police officer in the same circumstance. The UJI says reasonable person in the same circumstance. And I think the Mantelli case is instructive for this court. Let me get past, there's the Mantelli decision. That's what, I think at one point, Mr. Bregman said, Mantelli, Mantelli, Mantelli. I say, Your Honor, yes, I think there are some instructive things in Mantelli, and I'd like to compare the facts of Mantelli to our case. Because in the Mantelli case, Judge, the court found, even though it reversed it and said you need to go back and give a justifiable homicide instruction, they were also asked to look at whether the facts in that case were sufficient for conviction on voluntary manslaughter and aggravated battery by the police officer who shot into a car and killed a man. And what it says is, let's see if I can read it off of here. We have reviewed the record and find that there was substantial evidence to sustain the defendant's conviction, even under proper instructions. That is, sustain a conviction beyond a reasonable doubt. Not probable cause, but something to sustain a conviction. So what were the facts of Mantelli, and what are the facts here? In Mantelli, there were 2 suspects, not 1, like there were in this case. In Mantelli, there were 2 officers facing 2 suspects, not like here, where there were 19 officers facing 1 person. In Mantelli, the weapon was a car, a moving vehicle, with which he tried to run over the officers. In this case, it was 2 pocket knives, which for most of the encounter were kept in Mr. Boyd's pocket. In Mantelli, there was an escape risk because he had led these officers on a high-speed chase. They were concerned that he would get out into the community. In this case, Judge, no escape risk. He was surrounded. According to Sergeant Fox, he was going nowhere. There was no escape for James Boyd. Proximity, close, he fired from 1 arm's length away. In the Mantelli case, here they fired from 10 to 20 feet away, depending on whether it is Officer Sandy or Officer Pettis who is firing. The defendants in that case claimed the same thing the officers claimed here. They felt shocked and scared. They thought they were backing over his partner. There were potentially others in the area. Same thing as here. Perceived threat, thought they might come at them, potentially others in the area. Warning, there was no warning in Mantelli, something that the court criticized, and something that should be criticized here. Because if you recall, when the field officers were there, they told Mr. Boyd what they had was a beanbag shotgun, non-lethal round, and said to him, if you cross this line, we're going to shoot you with a beanbag shotgun. Then they were called off and they were replaced by the tactical team, the rope officers, the canine officers, and the SWAT officers who were arriving late to the scene. No one ever told Mr. Boyd at any time on that tape that they now had lethal weapons, or that they would use them against him, or they would shoot him with a lethal weapon rather than a non-lethal weapon. Also, when he pulled out the knives in response to the dogs in a defensive gesture, nobody said, get on the ground or we're going to shoot you. No one said that. They just told him to get on the ground, get on the ground. And even without the threat of shooting him, he got on the ground. He did what they said. Finally, the defense was that it was self-defense and protecting the other officer. That's the same thing they're claiming here. In this case, the court found that it was justified in our case, where he is less dangerous than were the suspects in Mantelli. The shooting is less justified. I mean, when you compare the facts, this would be a more dangerous suspect and a more justified shooting, and this would be a less dangerous suspect and a less justified shooting. What did they say in Mantelli? They said there were sufficient facts to convict beyond a reasonable doubt, and in this case, Judge, under the lessened standard of probable cause, that is just slightly more, 51%, there are sufficient facts to indict in this case. Again, I want to focus on the reasonable person standard. I think this is the thing that the court has been quoting, saying you look at the acts of the officers, not their training. Defendant has presented evidence that at a certain point the suspect presented a real threat to him and others. Whether that threat had dissipated sufficiently by the time he fired the fatal rounds to make his use of deadly force unreasonable was for the jury to decide. And that's almost the exact same situation we have here. The jury has to decide whether once Mr. Boyd turned away to follow the officers, the orders of these officers, whether he should be convicted. Just as the police officers should not be above the law, they should not be beneath its protections. The court understands that should you bind these officers over on probable cause on these charges, they will still be entitled to have a jury of 12 persons hear the matter, and all of them will have to decide beyond a reasonable doubt whether or not these charges should stand and they should be convicted. At this point, the court has ample evidence to find beyond, to find probable cause at least, that they should be bound over on the charge of second-degree murder, voluntary manslaughter, aggravated assault, and aggravated battery with a firearm. Thank you, Judge.
All right, thank you. Mr. Muller?
May it please the court,
Go ahead.
counsel. In December of 1770, before our country was even established, a group of British soldiers were put on trial for their actions in the so-called Boston Massacre. Popular opinion held that these officers had opened fire savagely on a group of unarmed Americans and fired for no reason. Those soldiers were therefore charged with murder. These soldiers were represented by a young John Adams, who agreed to take on representation in this case in the interest that these soldiers receive a fair trial. What happened next helped set the stage for the rule of law in this nation. Using the testimony of eyewitnesses who were able to give a more complete context to the danger that led the soldiers to fire, and citing laws that permitted firing under those circumstances, the future president won a complete acquittal for the majority of these soldiers, despite what had previously been the strong consensus that their actions had been without justification. In doing so, Mr. Adams used language that still resonates today. He suggested that facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence, nor is the law any less stable than the facts. Fast forward 250 years, and facts are still stubborn things. The law is still no less stable than the facts, and cases must still be decided and governed by that intersection of facts and law rather than popular opinion. Now, in evaluating this case, we must first strip away all of the legally irrelevant distractions that form the heart of the state's case. Like the public outcry about this incident, based on a combination of misinformation, invalid assumptions, and a lack of understanding about the context in which this shooting occurred. Now, if nothing else has been accomplished by this hearing, the facts of this case have received a full public airing and have hopefully brought about a clearer understanding of the incident. If nothing else, it should be clear to everyone now that James Boyd was not executed for being a homeless camper, and that trope needs to be put to bed forever. We must also strip away the legally irrelevant distractions like the insinuations and the arguments that this situation might possibly have turned out differently if only the open space officers had initially approached Mr. Boyd in a different manner, or if fewer officers carrying less protection had ultimately responded, or if officers had simply allowed Mr. Boyd to leave the scene on his own terms, fully armed, or sent him a few hundred feet away into the forest after he'd threatened them. And as long as we're engaging in speculation about how this incident might have turned out differently, what if Mr. Boyd had simply put down his knives one of the dozens of times he'd been asked and ordered to do so over the course of several hours? Or if the officers had just let him go on his way, and he had later assaulted one of the runners or hikers you saw in Alex Thixton's video, or one of the homeowners in whose home he was camping very close to. We all know where the blame would lie if the officers had followed this approach. But this is why speculation and hindsight, no matter how tempting it might be, serve no purpose in an evaluation of a case like this, and why the case law forbids it. We must strip away legally irrelevant distractions like the suggestion that the lawful justification for Officer Perez's use of force is somehow dependent on the actions of others, either in how they responded initially or in their independent decision to effect a legal arrest and the strategy that they used to attempt that arrest. As we discussed in depth during Officer Perez's initial motion to dismiss, the case law is crystal clear that defense of another or justifiable homicide by a police officer are dependent solely on a defendant's own actions and perspective, and the actions of others, even if they could somehow be interpreted to have created the need to use deadly force, cannot be held against a defendant. Under the law, Officer Perez can be responsible only for his own actions. And it's only by stripping away these legally irrelevant distractions that we can actually come to the crux of the matter in this case, a criminal prosecution against Officer Perez for his actions alone. And that crux is simply whether it was objectively reasonable to believe that James Boyd posed a threat of death or great bodily harm to Officer Weimerskirch or anyone else at the time Officer Perez made the decision to shoot. No more and no less. Now, despite what the state has said, by law, this determination must be made by looking only at the perspective of Officer Perez at the time he made the decision to use deadly force, and by looking only at the facts, and whether the facts before the court would warrant such a belief by a reasonable officer based upon the training, experience, and expertise of that officer under the totality of the circumstances. This requirement in the case law that the officer's perspective, training, and knowledge must be the basis of which the reasonableness of his actions are judged is actually reiterated and expressed a little bit more poetically in a 1988 case from the Seventh Circuit Court of Appeals, Sherrod v. Berry, at 856 Fed 2nd 802. Sherrod also involved an evaluation of the reasonableness of an officer's use of deadly force. And in finding that the officer's use of force was reasonable under those circumstances he confronted, the Sherrod court recognized that justice requires that an analysis of the reasonableness of an officer's actions be performed from his point of view, just as he was compelled to do in a split second on that fateful day. And in doing so, the court explicitly recognized that this standard is essentially an incorporation of the old Sioux prayer for wisdom, which the court characterized as, "Grant that I may not judge another before I've walked a mile in his moccasins." Such wisdom informed the court's decision in Sherrod and informs this court's task as well. And when all of the undisputed, stubborn facts that we've heard in this case regarding Officer Perez's perspective, his knowledge, and his training at the time he used deadly force against James Boyd are evaluating according to the principles mandated by the statute and the case law, it's clear that the state has not come forward with anywhere near sufficient evidence to demonstrate that it's reasonably probable that this use of force was legally unjustified under the circumstances. Now, before discussing the evidence before the court, it's essential, especially in light of the state's presentation on the law, to first briefly lay out the legal framework through which that evidence must be viewed. Of course, the first place any evaluation of a homicide by a police officer in the line of duty must begin is with Mantelli. Now, I imagine that after these past few weeks, if you never hear the name Mantelli again, it will probably be too soon. And yet, in addition to serving as the touchstone of this analysis by holding that a homicide is necessarily committed when a police officer has probable cause to believe that he or another is threatened with harm or deadly force while performing specified duties, Mantelli has several other essential components that must be taken into consideration as well. These components are not dependent on the facts of the case. Mantelli actually set out the framework through which any of these types of cases are to be viewed. In no way was it case specific. First, it recognizes that because police officers are obligated to make arrests, they don't always have the luxury of retreating if threatened or avoiding danger if a suspect does not comply with their commands. And the law provides them with a wider scope of privilege than the general public with regard to the use of deadly force. Citizens can retreat from dangerous situations because officers are expected to come and put themselves in harm's way in order to attempt to resolve a situation. Therefore, in order for deadly force to be justified, a police officer need only have probable cause to believe that he or another is threatened with serious harm or deadly force, as opposed to a non-officer whose actions require an appearance of imminent danger of death or great bodily harm in order to be justified. This recognition that the nature of an officer's obligations requires an expanded privilege for the use of deadly force is in keeping with long-standing New Mexico case law, seen in cases such as State v. Vargas, a 1937 NMSC 049. Vargas recognized that when making an arrest, the officer must of necessity be the aggressor. His mission is not accomplished when he wards off an assault. He must press forward and accomplish this object. And significantly, Vargas tells us an officer is not bound to put off the arrest until a more favorable time. Vargas also recognized that in making an arrest, an officer may use sufficient force to overcome resistance, and he is never required to afford the resisting offender the opportunities of a fair and equal struggle. Therefore, although Officer Perez strenuously contends that the actions of other officers are not to be taken into account in an evaluation of the justifiability of his actions, we raise these principles in light of the state's attempt to shift the focus to legally irrelevant issues. These principles and the testimony you've heard throughout this case illustrate why the actions of the other officers were justified and why the bar for evaluating the use of force by police officers is greatly raised in general. Second, Mantelli also recognizes, contrary to what the state said, that the uniform jury instruction on justifiable homicide by a police officer, 14-5173, does not reflect the current law of New Mexico on this issue as encapsulated by NMSA 30-2-6. It recognizes that the UJI looks to the reasonableness of the perception of a threat by a reasonable person in the same circumstances as the defendant. Whereas Mantelli specifically said the law requires that the analysis instead be based on the perspective of a reasonable police officer taking into account his training and experience. Again, not case specific. That is the framework. Third, Mantelli explicitly recognizes that an analysis of the use of deadly force in a criminal context must still be based on the Fourth Amendment's objective reasonableness framework as laid out in Tennessee v. Garner, Graham v. Connor, and the myriad federal civil rights excessive force cases that followed. In this regard, I'd also bring to the Court's attention the recent Michael Brelow case from Ohio, which a copy of which I believe was provided to the Court by Mr. Bregman at our July 31st motions hearing. That case involved the criminal prosecution of a Cleveland police officer for firing 15 shots through the windshield of a vehicle while standing on its hood, ultimately contributing to the death of the vehicle's two occupants. The Court found that the defendant's decision to use deadly force was based on probable cause to believe that the defendants posed a threat of serious bodily harm to him or other officers and was therefore reasonable. And in doing so, the Court recognized that the analytical framework for an officer-involved shooting must follow the Fourth Amendment analysis laid out in other excessive force cases, including civil cases, and be based on an objective reasonableness of the action based on the officer's perspective and the information available to him at the time that he acted. We've already discussed these key concepts from Fourth Amendment excessive force cases in earlier briefing and arguments, and many of them are so familiar to many of us that it's easy to gloss over them or to stop paying attention to what they're really saying. At some point they become almost like platitudes, and yet these concepts are tailor-made for a case like this to ensure that the focus is placed exactly where it belongs and not on side issues. and really focusing on them is essential to a proper evaluation of the evidence. Now, because the because the cases setting out these well-settled propositions of Fourth Amendment law do tend to be federal appellate court cases, I've taken the liberty of printing out and highlighting several of those cases for you to submit at the close of this argument. But when I speak of well-settled Fourth Amendment propositions that are essential to analyzing this case, I'm talking about such propositions as the Fourth Amendment does not require an officer to use the least forceful or even a less forceful alternative during an encounter, as long as the force actually used by the officer was objectively reasonable. The Fourth Amendment does not require a police officer to retreat when a subject threatens that officer or others with violence. An officer is allowed to rely on the accuracy of any information that they learn from a police radio dispatcher or a fellow officer. The actual state of mind and intentions of a suspect, such as whether they actually intend to follow through with a threat of violence or whether they actually intend to surrender if their outward actions show otherwise, are irrelevant to a Fourth Amendment objective reasonableness inquiry. Similarly, the motives or the state of mind of a defendant officer are irrelevant to such an inquiry. We know that in order to determine if a defendant's actions were objectively reasonable, the fact finder must consider all of the facts and circumstances, including the severity of the crime allegedly committed, in this case aggravated assault with a deadly weapon against a police officer, whether the decedent reasonably appeared to pose a threat to the officer's safety, and whether the decedent was actively resisting arrest or attempting to evade arrest. And perhaps most important to the analysis now before the court, completely different from what the state posited, the court must judge Officer Pettis' use of force from the perspective of a reasonable officer on the scene, evaluated from his perspective at the time of the incident, taking into account his training and experience, rather than with the 20/20 vision of hindsight that the state would have you do. And it must consider the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that's necessary in a particular situation. These are not guidelines to direct your analysis. They're directives from the case law. They are the law governing this case. Obviously, the point of a preliminary hearing is to evaluate whether the state has come forward with enough evidence to demonstrate that it's reasonably probable that the defendant committed the crime for which he's being charged. When this analytical framework and these key concepts are applied to the evidence before the court, the state cannot be found to have met its burden to demonstrate that it was objectively unreasonable for Officer Pettis to believe Mr. Boyd posed a threat of serious harm or deadly force to Officer Weimerskirch or others at the time he engaged him. Let's look at what the undisputed evidence, that series of stubborn facts, shows about Mr. Boyd's apparent threat level at the time he was shot. We have a situation in which a subject is armed with 2 knives and has been non-compliant for hours with requests and orders to disarm himself. A situation in which the officers are apparently no closer to achieving compliance than they had been at the start of the incident, despite having worked with a series of skilled negotiators using different tactics. A situation in which the officers were aware that the subject has a history of violent assaults, including assaults against a police officer and a corrections officer. A situation in which the subject has repeatedly threatened to murder the officers on scene. You heard the audio tape. A situation in which he kept drawing and reholstering his knives in a menacing way, over and over and over, in a manner that Sergeant Ingram testified led him to conclude he'd been practicing those moves for a long time. And ultimately, a situation in which the subject has drawn 2 knives, is less than 10 feet away from an unarmed officer over who he is towering. The courts give clear guidance as to how to evaluate this level of threat. The case law says you must evaluate, first, whether the officers ordered the suspect to drop his weapons and the suspect's compliance with police commands. Obviously, Mr. Boyd fails this test. It says to look at whether any hostile motions were made with the weapon towards the officers. The testimony and the video evidence takes care of this, as we see Mr. Boyd drop his bags, draw out the weapons he threatened to kill officers with, and make a motion, at least initially, towards Officer Weimerskirch. It says to consider the distance separating the officers from the suspect. Clearly, having less than 10 feet separating the officers from a blade of a knife constitutes a significant threat of death or serious harm. And finally, the court must consider the manifest intentions of the suspect. You've heard the testimony, the audio recordings. Mr. Boyd could hardly have been more clear in his declared intentions to kill the officers if they either tried to take him into custody or disarm him. And nothing in his actions indicates he was not prepared to back up his threats. One factor that is not listed as one to consider in evaluating the threat level posed by an individual, whether that person is surrounded or subject to containment by multiple officers. Now, the state is arguing that Mr. Boyd posed no threat to the officers or to anyone else because officers had established a perimeter. Certainly, they're exaggerating Sergeant Fox's testimony about the security of this perimeter, but you heard the testimony. I trust you to evaluate it for what it's worth. But they say there's no threat to the officers or anyone else because there's this perimeter, regardless of how solid it is, notwithstanding the fact that the light was fading rapidly at the time that the layered, less lethal response was implemented. But as illustrated in a 1992 Sixth Circuit case of Smith versus Freeland, 954 Fed 2nd 343, the containment of a subject is only relevant if the subject can, without question, be apprehended without causing further harm. It was the apprehension of this subject, the necessary apprehension, that threatened this further harm. And for this reason, circuit courts addressing the issue of containment have rejected the argument that a surrounded subject poses no threat to others. You've heard unrebutted testimony that under these undisputed circumstances, Mr. Boyd would be considered to pose a deadly threat from an objective standpoint. You heard the authoritative testimony from Ron McCarthy that any reasonably well-trained officer would view these circumstances as constituting a deadly threat and act accordingly. You heard testimony by Robert Johnston that Officer Perez himself was trained to view circumstances in which a man armed with 2 knives makes an aggressive gesture towards a contact officer as a deadly threat. You heard testimony from Sergeant Jim Fox that Officer Perez trained in just such scenarios, learning to discriminate in the blink of an eye a deadly threat from a non-deadly one. And that without question, he was trained to see this precise scenario as a deadly threat. But perhaps the best way to evaluate the level of threat is to look at the perception of the actual subject of the threat, Officer Weimerskirch, as expressed in the powerful testimony you just heard yesterday afternoon. Based on what he saw, excuse me, he could state unequivocally that his belief that Officers Perez and Sandy saved his life when they eliminated this threat. And let's also look at whether, given the deadly nature of that threat, it was objectively reasonable for Officer Perez to use deadly force to eliminate it. You heard unrebutted testimony from Ron McCarthy that the decision to use deadly force in this circumstance not only was consistent with his training, and not his training, but the training provided to tactical officers in general across the country, but that a failure to use deadly force in this situation would have been an abdication of his duty. You similarly heard unrebutted testimony from Robert Johnston, Dave Hubbard, and Sergeant Jim Fox, all of whom trained Officer Perez at different levels and in different contexts on the use of force, who uniformly established that his actions were precisely what they should have been given his state-mandated teachings. In this regard, two cases are particularly illustrative. First is a 10th Circuit case from 2008 that we've referenced once before, the State of Larson v. Murr, 511 Fed 3rd, 1255. In a State of Larson, the court held that from the perspective of a reasonable officer on the scene, the use of deadly force was objectively reasonable as a matter of law against a knife-wielding man under circumstances that included the fact that he had threatened violence, that he had the high ground over officers, that he took a step toward an officer with a blade tip pointing at him, and that he was less than 20 feet away from the officer at the time he was shot. A similar case from the 8th Circuit in 1993, Kruger v. Fuhrer, again found that an officer's use of deadly force was objectively reasonable as a matter of law when he shot a man who he knew to have committed an armed assault at a time that the man either pulled or even appeared to pull a knife from his waistband as the officer was closing distance on him. The appeals court found that no questions of fact precluded this legal ruling, despite the fact that the man had been shot twice in the back and once in the back of the head, because it was objectively reasonable for the officer to have believed that he faced a threat of serious physical harm under the circumstances. These cases help illustrate that even in a civil context, with a much lower burden of proof than in the criminal context, courts have the authority and the duty to prevent cases from moving forward to trial when the evidence indicates that the use of deadly force was objectively reasonable as a matter of law. The state has come forward with no evidence or testimony, not a single witness, to testify that anything Officer Perez did in using deadly force in this situation was improper or in any way contrary to the training that he received. Not the case officer, the case agent who investigated the entire incident and didn't find sufficient evidence to bring charges. Not an expert in police procedures or tactical training. Not an eyewitness who watched everything unfold. It's the state's burden to provide evidence that Officer Perez and his actions were unlawful in light of his perception and his training. It's not only utterly failed to come forward with its own affirmative evidence, but has failed to rebut any of the evidence and testimony to the contrary. Now, the state suggests, and it is only a suggestion, an argument rather than fact-based testimony, that Mr. Boyd was surrendering at the time the other officers implemented their layered, less lethal approach to effect his arrest, as they were trained to do. It also suggests, though perhaps with somewhat less conviction, that he was surrendering at the time he was shot, despite having drawn both knives, and the fact that he was still holding on to them. Common sense, as well as the officer's training and experience, say otherwise. Of course, the question is not whether Mr. Boyd actually was surrendering at either point, as that would call for an interpretation of his state of mind, which the case law says, for good reason, is not something that can be divined or should be taken into consideration. Instead, the question is what Mr. Boyd's objective cues would tell a reasonably well-trained officer about whether he should be interpreted to be surrendering and the level of apparent danger that he presented. And on this true issue, there's overwhelming evidence in favor of Officer Perez. You've heard the testimony of Officer Weimer-Skirch, backed by the audio evidence, that he repeatedly told Mr. Boyd he could not walk down from the mountain if he maintained possession of the knives. That in return, Mr. Boyd would become agitated, say the officers had no authority to order him to drop his weapons, and threaten to kill the officers if they tried to disarm him. This, of course, was after 3 hours of refusing to disarm himself, despite being ordered to do so literally hundreds of times. Officer Weimer-Skirch repeatedly stressed that Mr. Boyd was talking about picking up his bags and walking away, but that such an action without disarming himself would be non-compliant with his commands. The state would have you believe that remaining armed and simply picking up bags constitutes surrendering, that he attempted to comply. Even though it was a long time ago, I had asked the court to consider the testimony of the state's own witness, Brock Niprath, who testified that in his view, picking up the bags actually made Mr. Boyd more dangerous and certainly could not be interpreted to be an act of surrendering. Now, after being told repeatedly what he needed to do to be compliant and being told repeatedly what he could not do, that is, just walk down fully armed, who ever heard of surrendering by failing to do what you've been told repeatedly you must do, or by doing what you've been repeatedly told you must not do? You heard unrebutted testimony by both eyewitnesses and experts that at no point did Mr. Boyd manifest any objective cues that officers would be trained to interpret as an attempt to surrender. Finally, the state appears to suggest that even if Mr. Boyd posed a deadly threat a second or two before Officer Perez's bullet struck him, it must necessarily have been unreasonable to shoot him because the bullet ultimately struck him in the back. This argument defies what the testimony and our own life experiences tell us about the time it takes to make a decision and to physically react after making that decision, as well as the testimony about what the eye of a trained marksman can actually see once it acquires a target and locks focus on it through a sighting system. To give the state's theory any credit would be to ignore the admonition to consider that police officers are often forced to make split-second judgments in rapidly evolving and uncertain circumstances about the amount of force that's necessary. And the state's argument in this regard relies on a presumption that if someone is hit in the back, the shot must per se be unreasonable. Not a single case stands for that broad proposition, and for good reason. The physics of gunshots and the movement of the human body and the speed with which these events occur make any sort of absolute conclusion about the validity of a shot based on its final location impossible. You heard Dr. Lewinsky's testimony based on several extensive studies about the average time it takes well-trained officers to perform certain tasks, such as acquiring a sight even after the brain makes the go decision to shoot, beginning a trigger pull, completing a trigger pull, and stopping an action after the brain receives a signal to stop. But even if you don't give full credence to the precise average time figures provided by Dr. Lewinsky, you cannot ignore the conclusion dictated by your own life experiences that making decisions and beginning and completing actions do, in fact, take time, and not an insignificant amount of time, especially when the decisions are made that need to be made are complex, and the stress level is great, and the environment is filled with distractions and competing stimuli. The state's argument, and again, it is just that, an argument, not backed by evidence, is that Officer Perez could not reasonably have considered Mr. Boyd to pose a threat of serious harm to Officer Weimerskirch because he was hit in the back as he turned away, or as he was turned by Officer Sandy's first shot, a mere second after having been facing forward with knives. This argument, when you really look at the heart of it, relies on the absurd premise that seeing a threat, identifying it as a deadly threat, making the decision to shoot, acquiring the target, locking in aim through a sighting system, and pulling the trigger all happen instantaneously. Recall, he was hit when his back turned for the very first time, so he would have had to do that entire complex of things instantly. We know that is not how things work. Reactions to events and the actions based on those reactions take time. That's the wisdom of Dr. Lewinsky's unrebutted testimony, but it's also what we undeniably know intuitively from our own experiences. And to suggest that Officer Perez committed a criminal act because Mr. Boyd made a split-second turn well after any decision to shoot would necessarily have had to be made defies logic. Now, your job is obviously to sift through the evidence you've been presented at this hearing and decide if the state has provided enough evidence to demonstrate that it's reasonably probable that Officer Perez committed a crime. But one of the charges before you should not even require this analysis. In count 2 of the amended information, the state charged Officer Perez with aggravated assault with a deadly weapon. As the state acknowledged in its trial brief, this charge was brought to account for the possibility that Officer Perez would argue that none of his rounds struck Mr. Boyd. The state therefore pledged that it would drop this charge if Officer Perez did not claim at his hearing that all 3 of his shots missed. Based on this proffer by the state, Officer Perez did not make any claim at this hearing that all of his rounds missed Mr. Boyd and did not contest any of the evidence put forth by the state that his first shot hit Mr. Boyd. Therefore, pursuant to this agreement by the state, this charge should not be considered by the court and should be immediately dismissed. As for the remaining charges, the court must still analyze the evidence and determine if the state has provided enough to demonstrate that it's reasonably probable that Officer Perez actually committed either second-degree murder or voluntary manslaughter. In other words, whether the states come forward with sufficient evidence to demonstrate that Officer Perez's use of force was unjustified, legally. Your Honor has vocalized numerous times throughout this hearing that you recognize your role as the fact finder. I believe the term you used at least once was that you are the judge of the credibility of the witnesses. Not to determine whether there is a question of fact, but to actually act as the fact finder. It's not enough to say that even if all the testimony points but one way, it's insufficient because someone else could choose to disregard that testimony. You are the finder of fact who must weigh the evidence to determine whether there's enough to go forward. And not only has the state not provided evidence to contradict the testimony and conclusions presented by these witnesses, but it hasn't offered affirmative evidence of its own to demonstrate the probability that Officer Perez shot for a reason, any reason other than his objectively reasonable belief. But it's equally your job to act as the judge when it comes to the legal question of objective reasonableness. The Supreme Court in Scott v. Harris, 550 U.S. at 381, a 2007 case, was very clear that once the facts dictated by the record have been established, whether a defendant's actions were objectively reasonable, or on the flip side, whether a decedent's actions rose to the level of justifying deadly force, are pure questions of law. It's therefore your job at this point to also determine whether Officer Perez's actions were objectively reasonable under the circumstances, and if so, to end this case right now. I'm concerned about statements that have been made by the state earlier on in this case about how the evidentiary standard applied to this hearing, as far as whether to bind over the defendants, is a very low bar. Of course, the standard to be applied here is not the standard of beyond a reasonable doubt that the state would be faced with if this case is allowed to move forward. But if the procedural protections that this hearing offers defendants are to mean anything, the state must be held to the full level of affirmatively making a showing of reasonable probability. After all, this is not a possible cause hearing. It is a probable cause hearing. Incidentally, a number of courts have recognized that the reason there's a relatively lower bar at preliminary hearings is because they typically happen very early on in the proceedings. And there's an assumption that the state is going to develop significantly more evidence if the case continues. Now, if there's one thing I'm sure we can all agree on, it is that this has been a most atypical preliminary hearing as far as the amount of evidence developed and presented. What you've seen is the fully developed evidence, and almost certainly what would be presented if this case is forced to move forward. Now, I'm not suggesting that this means the standard should change, but I am suggesting that the meaning of this standard should be evaluated, taking into consideration that this was, for all practical purposes, a full trial rather than a preliminary investigation of the evidence. And that this is, for all practical purposes, the evidence that the state would have to use to try to prove beyond a reasonable doubt that Officer Perez did not have an objectively reasonable belief that Mr. Boyd posed a threat of serious injury or death to Officer Weimerskirch at the time that he acted. Contrary to what the state would have you believe, referencing these requirements that the reasonableness of an officer's actions must be judged from the perspective of an officer, or that any evaluation of their conduct must take into account the split-second nature of the decisions they're forced to make, is not an attempt by the defense to suggest that police officers' actions should never be questioned, or that their actions can never properly be evaluated by finders of fact that are not law enforcement officers. Certainly, there are those officers who do not uphold their sworn duty, who dishonor their profession, and who deserve to be punished criminally to the full extent of the law. But after all of these days of testimony, it should be clear that Dominique Perez is not that officer. The wisdom of the standard imparted by the applicable case law boils down to the fact that police officers are human beings tasked with a job that is at times incredibly difficult. How many of us are called upon to make life or death decisions in literally 1 to 2 seconds? Make the choice not to shoot, and you could be watching your fellow officer, who you're sworn and assigned to protect, bleed out in front of you. Or make the choice to shoot based on what you see, and you could be facing criminal charges and the end of life as you know it. No, the standard set forth for what fact finders must consider does not put officers above the law. But it does mean that a fact finder needs to make damn sure they're not helping put somebody operating in good faith according to their training in prison for, at worst, reacting a split second late. You now have the tools to view that infamous video with a different set of eyes. No longer is the potentially outraged citizen who sees only the last minutes of a confrontation without understanding what possible explanation there could be for these actions. You now know that what you see on the video does not reflect the full extent of reality. Now you have the wisdom and experience of Ron McCarthy, who can explain in detail not only why this entire incident unfolded as it did from a tactical standpoint, but also why Officer Perez's actions exemplified what a well-trained officer should do in his position. Now you have the teachings of Sergeant Fox, who could explain precisely what Officer Perez was trained to look for and do in this type of situation, and why his reaction was directly in accordance with that specific training. And you have the harrowing eyewitness views of Officer Weimerskirch and Sergeant Ingram, who can explain exactly how things came to pass and what level of threat they were placed with. In short, what you have now that was missing when the video was the only source of evidence, and as it continues to be the only basis for the accusation against this officer, is context. And that context means everything when it comes to evaluating a reasonable officer's perspective. We said on the first day that this case is a tragedy, and it is. But this tragedy should not be compounded by holding over for trial a man who, by all of the evidence and testimony, acted precisely according to his training and experience when faced with an apparent deadly threat. Justice requires that a man not face trial for doing what the law not only allowed, but practically compelled. You have it in your power to end this case now, to give this utterly decent man his life back. We respectfully ask you to do just that.
Thank you, counsel. Before we get started, let me take a 15-minute morning recess, and then we'll continue. Mr. Bregman, be in recess.
Well, guys,